I'll turn to the fifth case on this morning's docket. That is case number 108649 in the matter of Stephen C. Alberg.
May it please the Court, I'm Alexander M. Walzak, Deputy Disciplinary Administrator. Mr. Chief Justice, with the Court's permission, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
On June the 12th, 2012, an attorney disciplinary hearing heard the evidence against Mr. Alberg on the formal complaint. The formal complaint consisted of 3 sub-complaints. One was concerned the legal representations of Miss T.G. The second complaint concerned the representation of a lady by the name of K.J., and the third concerned a criminal conviction of 2 misdemeanors for the possession of marijuana as well as drug paraphernalia. At the panel hearing, the respondent stipulated to the criminal conduct that it violated 8.4, commission of a criminal offense, adversely reflecting on his truth and honesty. However, he contested the complaints and the factual allegations in the first 2 matters. After hearing the evidence, the panel hearing found in the representation of the first complaint, T.G., that the respondent violated 1.7 conflict of interest by getting into a personal relationship with the client, which materially limited the quality of his representation, as well as 1.8F, in that he engaged in a prohibited sexual conduct with the client, as well as numerous violations of 1.15, commingling of trust account funds, repeated lack of accounting, as well as making no-interest loans to himself. And the third representation concerned 2 findings by the panel. One was that the respondent who was representing a lady by the name of K.J. in a difficult divorce, because the divorce, the husband was in Africa, and so it was trying to resolve both the divorce as well as the division of marital property. The respondent submitted a billing statement to the court, which he admitted at the panel hearing contained false entries, and he was asking $184,000 of attorney's fees. After the hearing on the matter, the trial court knocked it down to $45,000. But there was, in that submission to the court, over 177 false or inflated entries to the court. After that act, the respondent turned around and filed an attorney's lien against the client, seeking not only the attorney's fees, but 1/3 of any type of recovery. There was a hearing on this in the trial court, as well as it was appealed to that decision against the respondent. He appealed it to the Kansas Court of Appeals, and the Kansas Court of Appeals also found that the conduct of seeking 1/3 contingency fee of a recovery from domestic relations case was a violation of 1.5. At the panel hearing, I recommended that the appropriate discipline in the case was disbarment based on the significance and the severity, really, of the 3 cases, and that the conduct just didn't occur in one case, it didn't occur at one time. It occurred over a number of years. There was actual injury in the case. The respondent requested censure, then censure be published in the Kansas report. The hearing panel recommended 2 years suspension from the practice of law. And then after the 2 years, if the respondent seeks reinstatement, that he provides evidence from his treatment provider as to his mental and emotional stability. They did not, however, recommend a 219 hearing. Before this court today, I recommend that the appropriate discipline is disbarment. That's all the comments I have. Are there any questions from the court?
Any questions of counsel? Thank you, counsel.
Thank you.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. I've been directed by my client to request a public censure, and he will address you at the conclusion of my brief remarks. I think it's important that the court understand that prior to this mess, this scenario, that my client had an absolutely clean record, had no problems in the practice of law. He had represented the young woman in a divorce many years before. She contacts him and asks for a meeting. They meet on the plaza at a restaurant where they discuss her domestic situation. She was separated from her husband. They then start an intimate relationship that very afternoon. That relationship goes on for approximately a year, and then they move in together. At some point after that luncheon on the plaza, which occurred on April, and as I remember it happened in July, a divorce is filed wherein my client was representing the young lady. It was a difficult divorce. The matter was settled finally, and a sum of $40-some-odd thousand was part of the settlement that was given to my client's client. That money, he attempted to get her to put it in an account at some brokerage house. She declined that and wanted it left in his trust account. Big mistake. Obviously, he had an absolute duty to say at that point, you can't do that. I'm not a bank. This is a trust account. That's commingling money. It commingles it with my own. I am not able to take any money from you and just leave it in as we leave it in a bank account. He put it in his trust account with her permission, and she admits this on the record. At times, she allowed him to borrow money from this $40-something-odd thousand. Well, romance fizzles after a while. He orders her to another bedroom. She leaves the house. The complaint is filed. None of this excuses my client's conduct. He was wrong to start in the relationship, although he thought that intimate relationship started prior to his representation. The panel felt otherwise. They thought the representation started that day at the restaurant on the plaza, although he never filed the divorce too much later on. He allowed that money to be placed in his trust account. We all know you can't leave money in your trust account like you're a brokerage account. He borrowed against it with her permission, which she admitted on the record, and later on ensues a civil lawsuit where she sues him for the work she did on his house, the cleanup she did on his house, the painting, the repairs that she did on his house. They have a civil lawsuit in Johnson County, and a verdict from some $20-odd thousand was returned against him, and he has paid that judgment. As my colleague indicates and the panel indicated, the jury found that my client breached his fiduciary duty. Steve used incredibly bad...
Mr. Ambrosio, what her lawsuit you mentioned was for services she performed. That was the quantum merit claim that the jury found?
Yes.
And then there was also a conversion claim.
Conversion account also, Your Honor.
And what was that about?
That may have been $10,000.
It was 12. I'm just wondering what that was for.
At some point, while the money was in his trust account,
right, he
indicated that, and she allowed him to borrow, that some of the money had not been returned on this note, on this borrowing pattern. Also, there was an attorney fee during the course of his living arrangements with the young woman. He indicated, you owe me $10,000. And so he kept that $10,000 or $7,500, I don't remember the amount is, as his attorney fee, and she indicates there was never any agreement to pay that type of attorney fee.
Okay.
I hope I'm answering your question.
Yes, you are. I just want to clarify, the way you were describing it, it sounded like it was for personal services she performed.
It was
fixing the house, but it also had to do with this whole arrangement and the funds that were in his account.
Absolutely, Your Honor. Absolutely. And incredibly bad judgment. I mean, And I think my client understands that now. I think he understands the seriousness of what was involved, and the marijuana is just another problem that we have on top of it all. I've tried to hook him up with KLAP. I know he's going to some counseling, because what I worry about is if this court suspends him, as opposed to something more, that he'll come back and he needs to deal with this addiction that he has. The case was reduced from a felony down to a misdemeanor. He was on probation. He had clean urine tests during the entire probation. He's clean and sober now, but I think that needs to continue during the course of his life, because regardless of what one feels about whether marijuana should be legal or not, in my lifetime certainly, it will never be legal in this state. And he's got to understand that regardless of his political thoughts about that drug, he's got to stay off it. He understands that what he did by stepping over the line with this young woman, and he understands that what he did by leaving money in his trust account was wrong, incredibly stupid. It was not just bad judgment, it was incredibly stupid, and I think we're going to hear from him now.
Ladies and gentlemen, I'm Steve Alberg. I've practiced law for 32 years. I think it's important for you to know a little bit about the man that you're going to judge. I can tell you that my great-great-great-grandfather settled in Compton, Kansas, the southern capital of this state. He fought with the Union, however, with the 15th Kansas Cavalry, cleaned out Cass, Clay, and Jackson counties under Lincoln's federal order, and that's where I come from. I come from pioneers who settled here in the 1850s. And my great-great-grandfather fought at the Battle of Westport, and I'm proud to be a Kansan, and always have been. And my great-uncles were Marines in World War II. I was in the Air Force. I know, John. I need to tell them who I am, though, John. Okay. And I spent 18 years in the service. Pilot, when NOM ended, I got RIFT, means reduction in force, made general's aide, and spent 18 years with the 442nd, volunteered to go to the first Gulf War. Our unit didn't go, even though we had A-10s at that time, and when I was younger, I was a little disappointed. I'm glad now that I didn't go, but at that time, I really wanted to. And that's, I went to law school here at Washburn, city attorney here in Topeka. Went up to Norfolk, Nebraska, and practiced law in a small town for 2 years. And the head partner of that law firm, a man named Frederick Deutsch, he was a destroyer commander in the Second World War. And whenever you did something in a file he didn't like, whether you won or not, he would pull you into his office and you'd stand in front of him, and the only thing you were allowed to say was, "No excuses, sir." And that's where I learned to practice law. We went in every morning at 7:30, partnership meeting on Fridays at 6:30, firm meeting. I wasn't a partner then, obviously. And then I came to Kansas City and started practicing in Kansas City, and I've been doing it for 32 years, doing litigation in the trenches, a lot of work comp, and a lot of domestic. Domestic can be a tough area of the law because there are so many emotions involved. In 2006, my wife, we'd lost a baby. My wife had a serious postpartum depression, and I saved her the first time, but I couldn't the second. She killed herself, and I was a little bummed out about that. And then 6 months later, I got a call from a gal. Went down to have lunch in the plaza. I was lonely. We sat down there. We talked about her separation. We talked about my wife's death. We talked about her sister coming from Africa. In fact, that was a big topic of the conversation that day, was her sister being stranded over here from Africa. They had a diamond mine over there, and they'd been in Africa for 15 years, and she'd come over here to take care of her mother, and was hit with a divorce a short time after she got here, and all her credit cards and everything were cut off, and she was left basically with a suitcase and a purse and a young son. And I ended up taking both of their divorces a couple of months later. My relationship did start with her before I had anything signed or any. We had a luncheon. We talked about a number of things, as I said, and then I went back to her apartment on the plaza, and that's where it all began. It's a very unusual divorce, and it took me and my assistant and I. It was 2 years of everything we could do to fight that divorce. I was always under the impression that there was $30 million involved in this diamond mine that they'd taken away from Executive Outcome, a mercenary group in Africa. It was a kind of an exotic situation, and I kind of saw myself as a white knight at that point, and I went and I got temporary orders. My original temporary orders were $50,000 in attorney's fees, child support, maintenance, and I was able to get him served in L.A., when he was here selling stones on HSN in the state of Kansas.
Counsel, before you proceed,
Yes, sir.
I just wanted to remind you that the disciplinary administrator has recommended to us today that you be disbarred.
I understand you.
And you have about 4 minutes left of time. If you could focus on why you should not be disbarred
Well,
and
yes, sir.
why instead you're asking us to provide you a published censure instead.
Yes, sir. Well, as I said, it's a very unusual situation. I never had an African divorce before, and so it's not a situation that's likely to come up again. And I recognize my mistakes. Biggest mistake was representing someone at that time who was close to my heart and trying to help her family, her sister, and I was not as careful as I should have been in a situation where my heart was involved, and I've learned a lot from that. And that is like a red flag, and those rules are set up to kind of create a fence or a red flag as you approach them, and I got too close. And I was really trying to help, and I never got paid a dime. And in any event, I only got her $1.6 million, and she was upset, and we had a big altercation. And
You really need to answer the Chief Justice.
I will, John. I will. I had a scenario on it. Your Honor, I didn't get things in writing as I normally do in cases because I was at a lower level of consciousness about what I was doing. I just didn't issue the orders I normally do, or my letter of representation. I didn't do things that I always do in this case, and I think a lot of it was due to the fact that I was involved with her sister, and that caused bad judgment. And I can see that now. I can see how your heart can you try to help, and how your heart can carry over into a situation where you shouldn't be. And I all I can say to this court is it was an unusual situation, and no excuses, ladies and gentlemen, no excuses. And I'm sorry. And it won't happen again. And as I say, it was an unusual situation, and I got caught up in it all, and away it went, and I'm so sorry. But I think now I understand that being a white knight, having a good heart, can lead you down a path to where the knight is killed on the rescue mission. And I think you need to be, I need to be more careful about that. And I let my heart lead, and I was weak at that time. And I just really don't feel that it'll ever happen again, Your Honor. I will not let it happen again. I know what I did. I know how I got involved.
Very well. Any further presentation from either of you gentlemen?
No, Your Honor.
No, sir. If you have any questions, I'd be more than happy to answer them.
Any questions of either of these gentlemen? I see none. Thank you both.
Thank you, Judge.
You had reserved 3 minutes for rebuttal.
Mr. Chief Justice, unless there's questions from the court, I waive rebuttal.
Do we have any further questions? I see none. Thank you.
Thank you, Your Honor.
Thank you all for your comments this morning. Court will take this matter under advisement. At this time, the court is adjourned.